Good afternoon, everybody, and welcome to Phil Fisher's session on the refresh of UK and EU direct marketing rules and new developments. My name is Leonie Parr. I am a partner in Phil Fisher's Privacy, Security and Information Law team based out of the London office. I am joined today by my colleagues Nuria Pastor, who is a director in the same team, and Camille Ebden, who is a senior associate in the same team. We are going to take you through, firstly, a refresh on some of the core obligations that apply when undertaking direct marketing campaigns. We'll look at the rules that apply in particular in a business to consumer context, as well as the rules that apply in a business to business context. And we'll also deal with some of the issues that arise in the context of data brokerage, so obtaining data from third-party sources and some of the things to think about in that particular context. We'll then move on and look at some new developments, in particular in relation to different types of marketing, such as social media marketing, and we'll touch on the relatively recently finalized guidance from the EDPB in relation to social media targeting. So on that note, I will hand over to Camille, who's going to take you through our part one, which is a refresh of the core obligations. And at that point, towards the end of that section, Nuria will pick up with data brokerage. So Camille.
Great, thanks very much, Leonie. So to start off with, what actually is direct marketing? Well, in the UK, in our Data Protection Act 2018, it's defined as the communication by whatever means of advertising or marketing material which is directed to particular individuals. Now, in other countries in the EEA, the definition might vary slightly, but the key distinguishing feature is always that the messages should be directed to particular individuals. And this means that direct marketing includes, for instance, online targeting. So if we could move to the next slide, please, Leonie. Great. So what are the laws that you need to think about when carrying out direct marketing? So firstly, where direct marketing involves processing personal data, you'll need to consider your GDPR obligations. So with transparency, you'll need to ensure that your privacy notice meets the requirements of Articles 13 and 14 GDPR regarding explaining how you'll be using personal data for direct marketing purposes. Now, you should also be making sure that you're providing your privacy notice at the point at which you're collecting personal data for the direct marketing purposes. So for instance, if you're asking people to sign up on your website to a newsletter, you should be directing people to your privacy notice at that point. Lawful basis. So for direct marketing, the lawful basis will either be legitimate interests or consent. Now, which one is going to depend on your direct marketing activity, the context, and your relationship with the individual. And the e-privacy rules will also sometimes determine which one you will be relying on. Accountability. So if you're relying on consent, then it's really important that you have records of who has consented to what and when. If you're relying on legitimate interests, you may want to have a legitimate interests assessment that records why you think you're justified in relying on those legitimate interests. Now, we've also highlighted here the right to object to direct marketing. This is an absolute right, so once someone exercises this right, do bear in mind that you have to comply with it. You won't have any grounds for sort of overriding grounds for not complying with someone's request to object to direct marketing. So moving on to e-privacy rules, we have the e-privacy directive, and this will apply where you're carrying out direct electronic marketing. So marketing by automated calls, fax, or electronic mail, such as emails and texts. Now, this has been implemented slightly differently across different EU member states, so you'll also need to consider local law implementations. In the UK, for instance, you'll need to consider the Privacy and Electronic Communication Regulations, known as PECA. And it's also worth bearing in mind that there are differences in local laws regarding how these e-privacy rules are implemented in relation to business and business to consumer marketing. Now, we've also mentioned here the draft e-privacy regulation. We've been waiting for it for quite some time, and we're still waiting for it to be finalized. It's currently undergoing the trilogue process. It's likely to have a transitional period of 24 months. So once it is finalized, there should be time to prepare for it before it comes into force. One expected effect of the draft e-privacy regulation is that across the board, you'll probably end up needing prior consent for business-to-business electronic mail marketing, unless the so-called soft opt-in exemption applies. And I'll be discussing that exemption in a bit more detail shortly. It's worth noting that also when the e-privacy regulation is implemented, due to Brexit, this isn't going to automatically affect the rules in the UK unless UK legislation changes to copy it. So next slide, please. Thank you. So the e-privacy directive has got different rules depending on the particular channel that you're using for your direct marketing. If we look firstly at electronic mail, this is defined as any text, voice, sound, or image message sent over a public communications network, which can be stored in the network or in the recipient's terminal equipment until it's collected by the recipient. So typical examples are text and email, but another example would be in-app messaging, where such messaging is stored until it's collected by the recipient. So under the e-privacy directive, the general rule for direct marketing via electronic mail is that you must obtain the prior consent of recipients. And that's the case unless the soft opt-in requirements are met. Now I'm going to go through the soft opt-in requirements on the next slide, but where it applies, it means that you can send marketing via emails, texts, and other forms of electronic mail to your existing customers without prior consent. So moving on to look at automated calls and faxes, you need prior consent for those under the e-privacy directive. And the directive then sets out that for other types of electronic marketing communications, it's down to the member states to either allow these with prior consent or on an opt-out basis only. So for live calls, you're going to need to check the local requirements. Many jurisdictions allow this to take place on an opt-out basis, but many will require you to screen against some sort of national opt-out list. And you should also be screening against your own opt-out list. Now, as we've mentioned, the implementation of the e-privacy directive rules do vary, and they particularly vary depending on whether the marketing is B2B or B2C. So do check the local rules. Regarding email marketing, Fieldfisher's got a helpful summary across all of the EEA countries and the UK, and we've got the URL on screen there. So if I move now to the next slide, thanks Leonie, I'll just take a look at the soft opt-in exemption in a bit more detail. So I mentioned that where this applies, it means that you can send direct marketing via emails, texts, or other forms of electronic mail to your existing customers without prior consent. So the e-privacy directive sets out that it will apply if you collected your customer's contact details in the context of a sale or a negotiation of a sale, if it's you that's sending the marketing and the marketing relates to your own products and or services that are similar to those for which the customer's details were originally obtained. And as long as the customer is given the opportunity free of charge to object to or opt out of the electronic mail marketing, both at the time their details were collected and in each subsequent communication. So As mentioned, different EU countries have implemented this differently. So it is worth having a look at our freely available document comparing the different rules across the different countries. And we also look at the different rules from a B2B and a B2C context. I'll hand over to Nuria now to have a look at using data brokers.
Thank you, Camille, and good afternoon, everyone. Thanks. So we'll now look at what you need to do where the personal data of the targets for your marketing activities has not been obtained directly by you, but by a third party or a data broker. So the ICO in its guidance defines data brokering as the activity whereby organizations collect data about individuals from a variety of sources, including publicly available sources. They combine it and then they sell it or rent it to third parties. So data brokers may provide other services as well, such as data matching, data cleansing, and data tracing, or profiling and data enrichment. So the compliance challenges faced by brokers themselves, I think, would be enough for a separate webinar. So what I'm going to do today is I'm going to focus on the compliance challenges from the point of view of the customer of the broker. So in other words, an organization that wishes to buy a database from a broker. So in relation to this, there are two golden rules that we need to remember. First of all, do not forget that the fact that somebody else has collected the data does not remove your requirements to comply with the law. Secondly, you will need to carry out appropriate due diligence in relation to the data you're planning to buy. And it's not enough for the broker to say in the contract that the database is quote unquote GDPR compliant. We've seen that and you hear that quite often. It's important to remember that carrying out these due diligence checks is part of your compliance with the GDPR accountability principle. So, in addition to the marketing regulations and complying with them, this is also relevant from a GDPR point of view. Let's move on to the next slide where we look at the due diligence exercise in a bit more detail. So the ICO in its guidance sets out a number of questions that you will need to ask the data broker before purchasing the database. And what's important to remember, obviously, because I'm fully aware that many of our attendees will have a presence outside of the UK or will wish to carry out marketing activities or marketing campaigns across Europe. These questions and these due diligence questions are also relevant for other countries. It's just that obviously they are based on ICO guidance because the ICO happens to have extensive guidance on this, but we have discussed this matter with our colleagues across Europe, and this also applies to other countries. So let's have a look at the questions that we should be asking. So first of all, who compiled the data? Was it the organization that you're buying it from, or was someone else? Where was the data obtained from? Did it come from the individuals directly, or was it, or has it come from other sources? Thirdly, and very importantly, what type of privacy information was used when the data was collected? What were the individuals told their data would be used for? Were the individuals given a privacy notice or not? Don't forget that under Article 14 of the GDPR, you are required to comply with the transparency requirements where you have not collected the information directly from the individual. And the exemption to this requirement, to this transparency requirement, for instance, the so-called disproportionate effort exemption, will only apply in very limited circumstances. We have seen this and how limited the application of this exemption is in a Polish case called Visnote, where an organization was fined because it applied the disproportionate effort exemption too loosely, if you like, or too broadly. And this was subject to a fine by the by the Polish regulator, and then confirmed by the Polish court. Moving on to the next question, it's important also to see when was the personal data compiled, so what day was it collected, and so how old it is. How was the personal data collected? Was it in the context, in what context it was, and what was the method of collection? Does the organization have records of consent, of the individual's consent, if consent is required, and if they are advertising this as consented data? What did the individuals consent to? What were they told? Were you named as an organization as a potential recipient of the data? When and how did they consent? Don't forget that in order for consent to be informed, the recipients have to be named. Next, it's in relation to the evidence that the data has been checked, as Camille was explaining, against opt-out lists. If that is claimed by the broker that they have screened the database against opt-out lists, this will have to be also checked and demonstrated. Don't forget that in the UK, this is a legal requirement for telephone marketing, but this requirement also exists in other European countries, and actually in some other European countries it's much broader. So it would also affect, for example, email marketing. And finally, how does the seller deal with individuals' rights, and do they pass on objections that they have received? Are they required to pass on objections to you? So as you can see, quite a few things to ask an inquiry about. And what's important to remember is that the answer to these questions should give you a picture about the quality of the data and whether it would be lawful for you to use it or not for your purposes. But also it's important to remember that if after having carried out the due diligence checks and if you're satisfied that it is lawful for you to use this data and you start using the data and something doesn't feel right. So for instance, you start receiving complaints from individuals or your emails are bounced back. So it might be that the database is actually not compliant enough or is not good enough. So you have to keep an eye on things after you've acquired the database as well. So that, if there are any red flags arising from the use of the database, you are aware of it. Before I move on to the next section of our presentation on social media, I just wanted to flag that, in particular in the UK, last year, the ICO audited some brokers and it issued recommendations which resulted in certain brokers removing certain products from the market and changing their data protection practices. In one instance, the ICO issued an enforcement notice to a data broker, compelling them to make changes within 9 months or face further action. So it's clear that this is high in the agenda of regulators, and I know of other European regulators as well for whom marketing is high in the agenda. One of the shortcomings identified by the ICO related to the provision of privacy notice that were not clear enough in relation to what the broker was going to do with personal data. So as ever, transparency is key. Let's move on to the part 2 of our presentation now.
Actually, Nuria, just before we move on to part 2, I think
Sure.
that there's a question that I think might be pertinent to ask now, because it specifically relates to one of the points you made about the necessity of recipients of the data being named. And the question is, well, that this may be impracticable,
Yeah.
where a broker is selling to an unknown number of potential clients. And the question really is, would naming the categories of recipient be enough in that particular context?
Yeah, it's a good question, because I totally agree that it's, in practice is really difficult, and that's probably what's done generally. Just refer to the categories. The requirement of having the named organizations comes from the regulatory guidance, both from the ICO and also consent guidance from the EDPB, in order, so when you're relying on consent, you would need, for consent to be informed, you would need to name the recipients of the data. So appreciate in practice it might be quite difficult, but that is how regulators would interpret this requirement. I don't know, Leonie,
Yeah,
whether
that's often one of
anything
the
else.
that's often one of the key challenges, isn't it? But I
Yeah,
think,
it is.
yeah, as you say, given that consent needs to meet GDPR standards in
Yeah.
order to be fully informed, then that requires the recipients to be named. So it does need, I think, a little bit of creativity around, well, how practicable is it going to be to achieve that? And it might be actually that the way it's done is after the event. And actually, when we look at the EDPB guidance on social media targeting, we'll see that sometimes you kind of have to match up consents across different players or in the relevant ecosystem in order to, facilitate an overall consent. So it might be that actually the consent, has to be obtained actually further down the chain by some other means and not necessarily by the broker. But I think the point is it's not going to be good enough to sort of rely on the means by which this has been done in the past, and warranties from brokers that all necessary consents have been obtained. There will need to be some thought around, well, have the consents really been obtained, and are they sufficient for GDPR purposes?
Yeah.
Exactly.
Exactly. But yeah, I think, as I said at the beginning, I think the challenges that brokers face could be the whole topic for just one webinar. But yeah. Okay. So moving on to thank you for the question, by the way. So I'm now going to move on to part 2 on social media marketing, and so if we move on to the next slide, please.
Sorry. Yeah.
So I guess some of those in the UK in the audience will be aware that the ICO has set out some specific guidance on social media marketing in its draft direct marketing code, but it's not very extensive. However, the EDPB, as Leonie was saying, has issued relatively recently a set of guidance on this particular topic. In relation to the EDPB guidance, as an overall comment, we would highlight that the tone of the EDPB guidance is quite negative in relation to social media marketing. So while this shouldn't come, I guess, as a surprise, the EDPB guidelines emphasize all of the risks and potential harms of targeting, such as discrimination, manipulation, and undue influence, but it doesn't pay attention to the positive aspects of targeting. So, for example, helping users deal with information overload or identifying products and services they are more likely to be interested in, or indeed helping businesses, in particular small businesses without strong brand recognition, to reach new customers and so on. So to present a more balanced, objective perspective, the paper would benefit from acknowledging some of the upsides as well as the downsides to marketing. But there you go. This is our opinion, I guess, as a team. Moving to specifics, today we will look at some of key concepts and terminology. We will also look at the roles of the parties involved in social media marketing. We look at lawful grounds for processing you may rely on, including whether processing, when processing special category data in this context. So let's have a look at the key concepts and terminology. Thank you. So first of all, we have the users. So this will be someone registered and who has an account or profile, and obviously is the data subject. Then we have the social media provider, which will be, the likes of Facebook or LinkedIn. And they enable the development of networks and communities of users amongst which information and content is shared. The social media provider determines functionalities of the platform, which will then has a knock-on effect on the data that is processed and for what purpose. Finally, social media providers have the ability to gather large amounts of data of account holders and other individuals, and regarding the use of the platform and also off-platform activity. Next, we have the targeters. These use social media in order to direct the specific messages at a set of social media users on the basis of a specific parameters or criteria. The targeters select the messages and or their intended audiences according to the perceived characteristics, interests, or preferences of the individuals concerned. And this practice is sometimes referred to as micro-targeting. The targeters might present their messages to individuals in different ways. So for instance, by displaying a personalized ad, for instance, via a banner, or in the context of a social media platform by displaying the message in the user feed or history. Alternatively, targeters might integrate social media pixels or plugins, etc., in their own website in order to track social media users. There are also other actors in this space. So we have the supply side platforms, data analytics companies, and so on. So it's a big and complex ad tech ecosystem, and we'll, as you will see as we go on. Let's move on to the next slide. Thank you. So the EDPB guidance looks at 3 types of social media targeting and the roles of the targeters and the social media providers for each category. So in particular, the EDPB works through examples of each category and indicates who determines the processes and the means. In the 3 instances that we have here, so in relation to marketing based on provided data, observed data, and inferred data, and I'll explain these concepts in a minute, the EDPB concludes that for social media marketing activities based on such types of data, the targeter and the social media provider would act as joint controllers. So let's have a quick look at what we mean by provided data. So a social media user might indicate when they register, for example, what their age is or gender, or what their marital status is, for example. And the social media provider, in turn, may enable targeting on the basis of these criteria. So that's the provided data. Moving on to observed data. This is data that is provided by virtue of using the service or the device. So for example, in a situation where a website publisher, who would be the targeter here, uses a social media pixel on its website via which it will obtain information about the user browsing on its website. And then this will result in displaying ads about its products and services when the individual uses the social media platform. And the third category, the inferred data, this is data created by the controller on the basis of the provided or the observed data. So for example, where an individual who, when using social media, likes a particular painter, may be included in the social media platform category of those interested in impressionism, then a museum might use the social media services to target these types of individuals to advertise a forthcoming exhibition. So as I said, in these 3 instances, the EDPB identifies the targeter and the social media platform as joint controllers. And now I'm going to hand over to Leonie, who will continue explaining the EDPB guidance on social media.
Thanks very much, Nuria. We thought it might be useful at this point, before I sort of launch into some of the discussion around the guidance, to just talk a little bit about possible different use cases or types of social media targeting. And so one type is, for example, core audience marketing. And typically what would happen in this context is that you have, obviously, on the one hand, the targeter or the advertiser, on the other hand, the social media provider. there will be a desire on the part of the advertiser to say target individuals falling into certain segments or categories or based on certain criteria such as gender or age or location or based on particular interests or whether they're part of a particular profession. And that is otherwise known as audience selection. So advertiser will be interested in selecting particular audiences. And then, based on those criteria, the social media provider will select from its database of users people who fall into the relevant audiences, and based on the criteria selected by the advertiser, and ads will be served to those users. So that's your core audience marketing. Then we have what's known as typically as list-based marketing. And that usually involves an element of data sharing, because we saw in the first instance here, the core audience marketing, that there isn't necessarily any data sharing by the targeter or the advertiser. It could be just that they select a criteria, and based on that criteria, the ads are served. List-based marketing, as I said, typically involves some kind of data sharing. Generally speaking, what often happens is the advertiser will upload to the social media platform somehow email addresses that are usually in hashed form. So they will be provided or put through a hashing mechanism and provided in hashed form. The social media platform in turn will produce a set of hashed email addresses from its own database, and there will be a matching exercise to determine whether any of the hashed emails match. And as you can see from this particular diagram, usually some of them will match and some of them won't match. So, we have here some common users across both the advertiser and the social media platform. Now that's generally done for one of two reasons. One, it could be to exclude a certain list of individuals. So the advertisers may, for example, conclude that they don't want certain users to be targeted because they've already targeted those particular users with their goods and services, and actually they want to target people who haven't been targeted before. And so the matching exercise will be to exclude certain users from the relevant campaign. In other cases, it is specifically for the purposes of retargeting existing users by the relevant advertiser or the targeter. Now, what's interesting in this context, as Nuria said, is that the EDBB seems to double down on this concept of joint controllership and takes the view that in this type of scenario, an advertiser and a social media platform are acting as joint controllers. Now, that point is likely to be, quite commercially sensitive to many advertisers, because it seems to assume actually that the email addresses will always be matched, and it doesn't take into consideration actually that some of them may not be matched. So for the unmatched email addresses, what the EDBB guidance seems to be suggesting is that the targeter and the social media platform are joint controllers, whereas traditionally a social media platform might have positioned itself as a data processor for that matching exercise and perhaps a separate controller for the subsequent targeting based on particular criteria. But the EDBB seems to take the view that, for the entire list-based marketing exercise, the parties are acting as joint controllers. Now, that, of course, does have particular implications because it means that there needs to be what's known as an Article 26 contract in place between the advertiser and the social media platform, addressing each party's respective responsibilities from a GDPR perspective, both in terms of, transparency and the exercise of data subject rights and accountability and all of the relevant GDPR obligations. Then we'll talk in a little bit about, some of the legal basis for the relevant marketing activity. So I'll come back to that in a few minutes. Okay, so that's list-based marketing. And then we've what's called lookalike marketing, which essentially involves, again, the advertiser providing certain data. And so it will provide certain data with certain profiles or criteria attached. So we'll upload certain audience information to the social media provider. The social media provider in turn will then check which of its users look like the users whose details have been provided by the advertiser. So for example, here we have Barney, we have Barney at rubble.com, looking very similar to Fred Flintstone on the basis that they're male, they're a dad, and they like bowling and beer. And so what happens then is that the social media provider identifies these users who look like the advertiser's existing users, and on that basis target the advertiser's marketing campaign at that users on the basis that there's an assumption they're more likely to take up or to convert against that advertising. Now, with that in mind, let's explore a little bit the lawful grounds for the data processing that's involved in these different types of activities. And the EDPB does comment on this, although it doesn't go into detail, for example, on lookalike marketing. But in relation to some of the other types of marketing, we can certainly extrapolate what it's saying about the potential lawful grounds for the relevant data processing. So in respect of targeting individuals on provided data, so data that's been provided to the social media provider, so such as gender and location, etc., and different types of profile information, is consent possible as a legal basis for processing that data? Well, the answer is yes. But equally in that context, legitimate interest, it appears from the EDPB guidance, is also possible. In terms of targeting individuals on the basis of provided data, so data that's provided to the targeter, again, the EDPB guidance envisages that could be potentially done either on the basis of consent or on the basis of legitimate interests. So for that list-based targeting scenario that we outlined, the EDPB guidance leaves open the possibility of relying on legitimate interest for that type of targeting. Now that differs from the ICO's current position in its draft ICO direct marketing code, because in relation to that list-based marketing that we described earlier, the ICO's code seems to suggest that consent would be required in relation to the providing of the email addresses for matching purposes and the subsequent targeting activity. That also chimes with a decision from the German courts, which confirmed a decision of the Bavarian Data Protection Authority to the effect that consent is required, for the sharing of emails for list-based marketing purposes. So there is a slight divergence as between the draft ICO guidance and the EDPB guidance on this particular point. As regards targeting on the basis of observed data, so pixel-based targeting or social media plugins, is consent possible? Well, yes, and in fact, it's required to the extent that there is the use of cookies. So to the extent that there's accessing information on a device or storing information on a device, then consent actually will be required. Is it possible to rely on legitimate interests? Well, no, not for the storage of or access to information stored on a device via cookies, because you need consent under the Privacy Directive. However, it may be possible, according to the EDPB guidance, to rely on legitimate interests for subsequent downstream processing of personal data. And that might include, for example, use of personal data for targeted advertising purposes. However, the guidance seems to suggest, and this sort of reinforces earlier guidance from the Article 29 Working Party opinion, that if the targeted advertising is based on tracking individuals across websites and across locations or across devices or across services, or involves getting data from third-party sources, that goes a bit too far from an intrusiveness perspective in order to be able to rely on legitimate interests. And the suggestion is that consent is the appropriate basis in those circumstances. And that does chime with other regulatory guidance in the ad tech space more generally, and the sort of general regulatory trajectory towards consent, to the extent, you know, that there is tracking across various websites and matching data with data obtained from various sources. As regards targeting on the basis of observed data or geo-targeting, again, what the EDPB guidance says is that, yes, consent is a possible basis for processing. And again, it is required to the extent that here again, cookies are likely to be used. As regards whether legitimate interest is possible, well, again, it won't be possible to rely on legitimate interest for the storage or access to information stored on a device via cookies. And because you're monitoring across locations and this is regarded as intrusive, then it's unlikely that you would be able to rely on legitimate interest for targeting based off geolocations. As regards targeting based on inferred data, what the EDPB guidance says is that, again, consent is a possible appropriate legal basis. And again, because usually this type of targeting will involve cookies, then the EDPB or the e-privacy directive requirements may be triggered. There's also a possibility that automated decision-making rules may be triggered. And so what do I mean there? Well, in some cases, based on inferred data, particular decisions are made about individuals. So based on inferred data about what I might like or what my behavior might be, I might be served a particular ad. Now, under Article 22 of the GDPR, there is a prohibition on decision making based solely on automated processing including profiling. Now, generally speaking, run-of-the-mill targeted advertising, you know, the prohibition relates to decision making based solely on automated processing that has a legal or similarly significant effect. Now, generally speaking, run-of-the-mill targeted advertising won't be regarded as having a legal or similarly significant effect if it's just, you know, I'm being targeted with a pair of shoes based on a profile that I'm, you know, really into running. However, there is a recognition by regulators that in some cases targeted advertising may be regarded as crossing a particular line and may be regarded as having, you know, as a decision that involves a legal or similarly significant effect, insofar as, you know, I might be targeted, for example, if I'm financially vulnerable with betting ads, or you know, if I'm a child, I might be targeted with over intrusive advertising, then that might be crossing the line into the realm of automated decision making having a legal or similarly significant effect, in which case explicit consent requirement is triggered. Then, in terms of whether legitimate interest is possible, again, it may be possible to target based on inferred data off the back of legitimate interest, as long as you're not using cookies and you're not engaging in automated decision making that has a legal or similarly significant effect. But again, to the extent that there's any kind of monitoring across websites or locations or devices or services, or if there's data brokering involved, then again, it's unlikely that it would be possible to rely on legitimate interest according to the EDPB guidance. Okay, so I mentioned the Bavarian case, and that confirmed a decision of the Bavarian DPA relating to list-based marketing, which basically indicated that consent is required for this type of marketing. And it also made the point that, you know, hashed email addresses is personal data, it's not anonymized data. So conversely, as I've said, the EDPB guidance appears to allow for the possibility of reliance on legitimate interest for list-based marketing. You know, in practice, it's quite likely that many organizations will, at least for now, continue to rely on legitimate interests, but obviously that involves a risk-based approach. in order to mitigate the risk involved in reliance on legitimate interests, then it's important to ensure, transparency around the use of, email addresses for this type of list-based targeting activity. It's a good idea to make sure that any direct marketing that you engage in is linked to services that have already been provided to the user. And it's also a good idea, and in fact, again, it's a point made by the EDPB guidance that users should be provided with the ability to object to this list-based targeting. We would often recommend also as a risk mitigation measure that organizations only engage in list-based marketing to individuals who have opted into their, email direct marketing. Okay, so on that basis, it's probably a good idea to exclude from any, uploads to a social media provider anyone who has opted out of email marketing. Just some final words then on special category data. The EDPB acknowledges in its guidance that special category data can be inferred from social media data. In other words, data doesn't always have to be explicitly sensitive to qualify as special category data. However, the guidance is quite helpful because the EDPB acknowledges that actually the mere fact that a social media provider processes large amounts of data which could potentially be used to infer special category data doesn't automatically mean that that processing falls under Article 9 of the GDPR, which deals with special category data. So Article 9, it says, will not be triggered if the social media provider's processing does not result in the inferences of special category data, and the social media provider has taken measures to prevent that special category data can be inferred or used for targeting. So in other words, context and measures taken to prevent inferences of special category data are absolutely key in that regard. So for example, data that reveals that a user has, regularly visited a place, typically visited by people with certain religious beliefs, will not necessarily of itself constitute special category data. But if it was used to infer special category data and target on the basis of religion, for example, then obviously that would change the situation. But generally speaking, of itself, it's not necessarily enough to bring it within the definition of special category data. But as I've mentioned, one mitigation factor that's outlined within the guidelines is, taking of certain measures to prevent that type of data being inferred. Okay. There isn't any commentary, and it would have been useful to have some if, is commentary on whether special categories of data could be construed to include sort of non-sensitive health conditions, like season allergy products or prescription lenses. It didn't, again, it would have been useful if we could have had a sort of an opinion on that and sort of the risk aspects of that particular point. But, because as things stand, technically those do fall within the scope of special category data under the GDPR. So by way of key takeaways then, as Camille pointed out, there are differing obligations across EU jurisdictions with regard to direct marketing obligations. So unfortunately, at the moment, there's no one-size-fits-all approach, and there will be different rules. So for example, in Germany, there's a double opt-in requirement in relation to both B2B and B2C marketing, unless, a soft opt-in exemption applies. So there will be a need to check the differing obligations and requirements in each country. As Camille mentioned also, we do have a PDF on our website which sets out the different B2B marketing rules across different EU jurisdictions. A key takeaway in the context of the EDPB guidance and social media marketing is the necessity to consider the implications of joint controllership and any terms and conditions that you might have with a social media provider if you're acting as an advertiser, and in particular to what extent those terms and conditions set out the respective data protection responsibilities between the parties. And it's also important to understand the lawful basis on which you're relying for the relevant targeting. And if you are seeking to rely on legitimate interests, making sure that you have appropriate transparency, that ideally you provide people with a means of opting out of the relevant social media targeting, and that if you are relying on legitimate interest, that you would also have some kind of legitimate interest assessment. Nuria talked about third-party brokers and obtaining data from third-party sources, and the need in particular to conduct extensive due diligence when using third-party data and not simply relying on warranties that are provided within the contract. So that brings us to the end of the main session with 10 minutes to go. So I think we have a little bit of time to address some of the questions that have been coming through. And so one of the questions, and maybe Camille, if it's okay, I'll just start with you because it looks like this would be one for you. The question relates to the rules in relation to withdrawing consent, and to what extent there are any rules about how you present individuals with the means of withdrawing their consent. So if you wouldn't mind commenting on that, that would be great.
Sure. So first off, as mentioned earlier, always bear in mind that under the GDPR that individuals do have an absolute right to object to direct marketing, and you do have to comply with it. You should also make sure that you're telling individuals before they provide their consent that they can withdraw it at any time. So you should factor that in when you are putting together your consent request language. And then I'd also bear in mind that the GDPR sets out that it has to be as easy to withdraw consent as it was to provide it. So if you have a very simple consent process that involves sort of checking a single box, you shouldn't then have a much more convoluted process for withdrawing that consent. If it takes one click essentially to consent, but it takes several clicks and going through different pages to withdraw that consent, regulators wouldn't consider that to be fair, and as that would be sort of breaching that obligation to make consent as easy as it was to provide it, as to make it as easy to withdraw consent as it was to give it. And then the last thing I would say on methods of allowing people to withdraw their consent is to just make it very clear as well. Under the GDPR, you should always make sure that you're being very transparent and clear. So, which also goes to that point of not making it very convoluted and complicated.
Okay, great. Thank you very much. Now, there are a few questions on the soft opt-in exemption and B2B marketing. Maybe Nuria, I could go to you just in relation to B2B marketing. There's a question around, how handling B2B marketing where data is obtained from, third-party sources, for example, and, what the rules would be in that particular context.
Thank you. Thanks, Leonie. You mean from public available sources?
Yeah, so public.
Yeah.
So I guess it would be the likes of professional websites and others.
Yeah, absolutely. So I would say, and again, that was in a B2B context. So I think we need to take two things into account. So very often our sales teams, sales teams will want to contact individuals who they've seen on LinkedIn or on a potential target's website. So the question is whether you can do that. So I think we need to look at two things. So on the one side, you need to look at the rules on B2B marketing that derive from the marketing regulations as such, which Camille explained earlier. So, whether you need consent or not, or whether you need, and depending on the way in which you want to contact that individual. So, whether you want to contact them by email or phone or by an email on a social media platform. So you need to look at what do you want to do and what rules apply. in many European countries, the B2B marketing can be done on the basis of opt-out, generally across the board, regardless of the channel. But there are other European countries where you will require consent for some of these, and therefore you will be limited. Or if you decide to do this, you will have to take a risk-based approach, because obviously it won't be fully compliant. But the other thing that we need to remember always is that when obtaining that information, the fact that the information is publicly available doesn't mean that it's there for anyone to record in their internal databases or CRM systems. So obviously, you will still need to comply with the GDPR and local data protection laws. So if you're obtaining that information from a source, so it's not directly from the individual, you will need to comply with Article 14 of the GDPR. So you'll need to check whether individuals have been given certain notices. In the past, in this case, they won't have been, because obviously they haven't, the data hasn't been obtained, first of all, by a broker or yourself. So you'll need to provide a notice to the individuals in relation to your processing activities, explain to them where you've obtained their personal data from, and you'll need to do that within certain timescales. So you'll need to do that normally by the time you contact them, or within a month. But if you're planning to contact them before that, it should be at your first contact. So again, I think golden rule, remember that on the one hand, you have the marketing rules, and this will change from a country, on a country to country basis. But then the other, don't forget about the GDPR and the transparency requirements, and the fact, obviously, that you'll also need legal grounds for processing. So if consent is required under marketing rules, that's probably going to be your legal grounds for processing. If you may do this on the basis of opt-out, you will probably then rely on your legitimate interest to do so. Sorry, a bit of a long-winded answer, but there are lots
No
of
problem. Actually,
consider.
that leads quite nicely into another question, also on the area of B2B marketing and soft opt-in, which I'm happy to take for the last few minutes. I think we have about 3 minutes left, so I'll quickly answer this. So it relates to the scenario where data for existing customers may have been obtained from a number of sources, and how does the soft opt-in work in that particular context, in terms of giving people, an opt-out at the time of collection of the data? Now, I think it's important to note here that the application of the soft opt-in exemption is it needs to be applied in a very narrow way, and there's quite a number of hurdles to be complied with before you can rely on it. And one of the key things to note is that the marketing based on soft opt-in exemption must be by the same entity that collected the data in the first place. So if you do have a scenario where the data has been collected from a number of different sources, then that immediately means that you're not going to be able to rely on soft opt-in exemption, because it means that the data was originally collected by another entity. And so therefore that sort of rules out the possibility of reliance on soft opt-in exemption in that particular case. It might be helpful as well to just mention, against that background, that the reason why the rules differ so significantly from one EU jurisdiction to another is that there was an update to the Privacy Directive in 2009 in relation to B2B marketing. And the update basically extended the rules on consent that applied in a B2C context to the B2B context. But not every country implemented that update. And that's why we had, divergence across the EU, in terms of the way business to business e-marketing is handled. And that in turn sort of led to us producing that PDF that I mentioned earlier. But Camille mentioned at the outset, we do have the draft e-privacy regulation. So it is expected that the rules in relation to B2B marketing will, become more uniform under that regime. And so that, the same rules will apply across the board, which of course will inevitably be that the more the stricter opt-in rules will apply, except in terms of the application of the soft opt-in exemption. So that's just a little bit of a potted history on why things developed the way they did. But I think that brings us to the very end. It's exactly 5 o'clock. I hope it has been useful. I'm conscious that there are a number of questions that we didn't get around to answering. Nuri and Camille and I will follow up in relation to those questions. And thank you very much for your attention.